We should go ahead and get started. I know we will probably be getting more people popping in as we start, but I don't want to waste any time because we only have an hour tonight, and I think that there's a lot of information that will be shared, and then I want to make sure that we take advantage of that time. My name is Joshua Williams. I am the director of the Fashion Management program at Parsons School of Design. It's a master's degree program that focuses on fashion systems from a global perspective and really helps students to understand all of the complex pieces that go into the fashion system, specifically from the side of logistics, tech and innovation, retail and service design, marketing and communication. So we really run the gamut. And so it's really an exciting opportunity today to host an event like this, which is one of the first that we're doing. And hopefully, if this proves to be useful and enjoyable and well attended as we think it will be, that we'll continue to offer these types of things as a service to the community, both inside Parsons School of Design, but also outside, including our alumni and friends of Parsons. So we welcome you all tonight to this first inaugural event with Mickelson IP. The Mickelson Institute for Intellectual Property is an initiative of the Mickelson 20mm Foundation, which provides budding inventors and entrepreneurs with access to free IP educational resources, including a digital textbook and online courses. And for those of you who are interested, you can learn more by going to mickelsonip.com. We'll be posting that in the chat, so you can click on that. Jelani and Rochelle of the Mickelson IP team will be providing links ongoing through the chat, and thanks to both of them for helping to make this happen. In addition, thank you to Daniel and Danny Cohen, Daniel Jacobs and Danny Cohen for being a part of this here on the New York side and helping make this a reality. So as many of you probably know or want to know, the focus of tonight is on IP and how it really affects the issues around fashion design, and fashion products and service delivery at a global community. And so we've invited two guests with us tonight. The first is Keanan Duffty, who was the founding director of this program. So it's exciting to have him back. He's now the director of fashion programs here at Parsons School of Design. And Paul E. Loving, who's senior counsel at Holland Knight. We're also, as I mentioned, Danny Cohen is one of our Mickelson IP guests, and she'll be moderating the event. But before we jump in, I would love to have Keanan first, and then we'll be followed by Paul. Just give a brief summary of your career and who you are so that we have some context for tonight's discussion. And then I'll turn the time over to Danny.
Sure, thanks, Josh. Thanks for that introduction. It's such a pleasure to join everyone today. As Josh said, I'm director of fashion programs at Parsons. What that means is I build a lot of content that's distributed both online and on site for continuing and professional education. So sort of moving outside of the sort of student-centric sphere and more to continuing ed and executives in the industry as well. I'm a designer by trade, and you know, I'm sure we'll speak about this a little bit later as we get questions coming in. But I've probably made every IP mistake you can make along the way. So you know, I'm kind of very experienced with intellectual property, from not correctly protecting my brand name when I started to infringing on the copyrights of Disney, which was fun. But yeah, I'm really looking forward to having this conversation today. And without more ado, I'll pass over to Paul and let him introduce himself.
It's wonderful, Keanan. Thank you so much. Yeah, the Disney lawyers are not a lot of fun to deal with, unfortunately. So I am a lawyer, and I do business transactions, intellectual property. The fun thing about what I get to do is I get to do a lot of work in the sports entertainment areas. So I've worked in-house at Nike. So I've done a lot of work in the athletic and lifestyle area. My largest client today is Adidas, and I've done everything from the deal with Kanye West to working with Jerry Lorenzo and Fear of God to working on Y3 with Yoji. So I've got a good taste of you know, athletic, athleisure, casual, lifestyle fashion, leading up to some of the higher end things, and represented individuals in the industry as well. So I'm looking forward to talking to folks, answering questions, and staying away from the Disney lawyers.
Me too.
Well, thank you guys for joining us. Hi, everyone. I'm Danny. I am a fellow at the Mickelson Institute, along with my colleague who's also here, Daniel Jacobs, who helped put this event together with me. So I'll be moderating, and I'll start by asking the questions that were submitted beforehand. And then as we go along, if people want to write their questions in the chat, I can read those too. So lastly, please try and stay until the end, as all attendees will be entered into a raffle for a chance to win a $25 Visa gift card. And that will be announced at the end. So we're going to kick it off broadly with one of the more broad questions. And either of you can answer. Some of the questions are directed at one of you in particular, but feel free to just decide as we go along who wants to speak first. So what are the biggest challenges faced by the fashion industry when it comes to brand protection?
I can go ahead and jump in with that. I think so. I'll kind of give an example, and that will probably illustrate my thought best. So when I started my brand, which was in the 90s, I moved to New York, and I decided in order to get an H-1 visa, I decided to incorporate a company, and that company would sponsor me. Don't try this at home, folks. It doesn't work anymore. But that company, which was incorporated with the name Slinky Vagabond, which is a lyric from a David Bowie song. And I thought, nobody will use a crazy name like that. So it's kind of fine to go ahead and incorporate that with that. And then also use that as my brand name. And therein lies the initial mistake. What I didn't do was do a thorough search before I actually started trading using that name. So I started doing runway shows, selling products to very high profile stores. And very, very rapidly, I got a cease and desist from a company in Sweden, who I believe they're in Sweden, called Vagabond, who make shoes. And so to cut a long story short, after hiring legal representation in Europe and going through a process of 2 years of back and forth, trying to wrangle the rights to a name that I'd already started using without trademarking at first, and thinking that because I had an incorporated company with that name, I had some ownership over the name, and I had a website with that name, that I therefore own the name. That was, kind of mistake 101. I would say that with any new brand, when you're starting out, the due diligence that you do before you actually start producing product and marketing yourself is so important. And that's really where you can find yourself with a major setback if you start trading without doing that first. It's an expense to a degree. It's legwork, it's time. But I think that is one of the initial steps that you really need to do to protect any brand that you're creating or you're working with. If you're working in your own name, it's slightly different. But if you're creating or it can be different, unless your name's Paul Smith or Giorgio Armani, in which case they're already taken. But that's, I think, one of the tricky things is that especially young brands and young designers often start with a brand name and probably don't necessarily do the due diligence beforehand to find out whether that name is an infringement on someone else's trademark.
So I want to pick up on that with what Keanan just said. There's a couple of things you can do without hiring a lawyer to try to see what the landscape looks like. The first is Google, right, or any search engine. You do a Google search for the title of what your brand is, and that will give you direct hits, right? So at least you can knock out certain areas of risk, of legal risk. The other is to go to the US Patent and Trademark Office, where you can actually do a search. Again, this is all without a lawyer, something you can do very quickly and easily. Again, that will only give you a direct hit, but that way you know whether or not your name is actually taken, the brand that you're trying to create, and you can avoid some of the issues that Keanan talked about. The last place you can go is depending on the state that you're incorporating in. The Secretary of State's office, usually in each of those states, is who basically registers corporations in the state. and you can run the name through that particular state registration. That'll again just show you who's registered in the state. It won't show you nationally or even internationally, right? And so when you've got a brand, Keanan was growing his brand not only domestically, but he was going to grow it internationally. You've got to not only think about what's happening here in the US, but also what's happening outside the US. So there's steps to go through before you actually have to get to a lawyer and waste money. Oftentimes what will happen is folks will go to a lawyer, they'll say, here's my brand. They won't have an alternative name. You'll search it. It won't be available. And then you're kind of stuck back at the drawing board in terms of trying to figure out what to do.
And just to sort of piggyback on that, I think, Paul's giving really, really excellent advice. In my defense, Google and really the internet weren't really in full swing in 1995 or whenever it was. But nevertheless, you still could do that legwork yourself at that time, which I didn't do. One of the issues that you also need to think about is which category you're going to trademark your brand in. I think that's a really important thing. I was initially making clothes, and I then struck a deal with Reebok. So I had a co-branded product with Reebok for 3 years, and that's when the flags went up from the folks in Scandinavia, because they saw dollar signs with that. In a similar way to to my encroachment on Disney's intellectual property, which again, these are all things that as Paul said, they're very straightforward ways to actually do that initial investigation and look into whether there is a potential infringement later. And I would really strongly recommend that anybody does that from my own failure to do that.
No, and Keanan's example is really good, because when you think about starting a business and wanting to grow the business, when you start off originally, you're under the radar, right? And there are lots of small brands that have gotten away with infringement, not only of names, but of other people's IP, copyrights, because there's just no visibility. But when you strike a deal with a major brand, an international brand like Reebok, you immediately hit the radar of everyone. And so, if you're starting off in business, right, your goal was to actually grow your brand and actually sell more and more products. But once you kind of hit that point up and over the ridge where you've got visibility is where you can have problems. And if you've had years of creating the brand and putting in at a local level, right? Let's say you're in New York and you've got a great name in New York, and now you expand and you've got to start all over, it makes it very difficult and very painful financially.
Yeah.
On that note, Paul, one of the questions we had was, how do IP laws in fashion in the US compare to other countries? And if they are different, how do you protect a product that is global?
Sure. So and this goes back to Keanan's example, right? You do have to think locally and then globally, right? Because if the goal is to truly expand out, you've got to think about the intellectual property laws of other jurisdictions around the world. When you think about the trademark world, well, let's start there first. You can get trademark registrations throughout the world, and there are different ways to basically combine a number of countries into a single application. There's legislation from years ago that helped to facilitate that and to streamline that process, because it used to be you had to go country to country to country to country, and now that's gone. You can go for a larger, like the EU, you can get a registration through the EU. There's ways to do it through North America, but there are ways now to be able to take your brand global because of the importance very quickly. So the differences oftentimes, though, are not so much on the patent or the trademark side, though that's pretty uniform. There are some differences in Europe. So for example, there's a lot of what's called patent trolls here in the United States, people who accumulate patents and then basically go out and they, I guess if you're a patent troll, you probably wouldn't describe it this way. They go out and they basically extract money from folks for infringing their patent. In essence, they're just warehousing the patents. They're not actually actively using them, but they are using them as a source of revenue. You don't have so much of that in Europe, because in Europe, in order to bring a suit, you have to post a bond. And if you lose, the bond can be waived. So you basically lose all that money you posted in connection with the bond. So people are more reluctant, I should say, to be patent trolls in Europe. So there are a number of international differences, and far too many to talk about here. There's issues with first to file, right? With disclosure on patents. There's restrictions about once you disclose your invention, how long you have to be able to register it. Whether if it's disclosed first, in certain countries, you've now lost the ability to get that patent protection as opposed to keeping things confidential. So the landscape is filled with lots of minefields. That's why I would say that Mickelson Institute, it is great to be able to have some resources to be able to look at to see what those issues are.
I think, can I just add to that, I think one good question to ask yourself is to think about where you're going to be trading initially. And, you know, what I did initially was I knew I was going to be trading in the US. I knew Japan was potentially a very good market for me, which it was. And I knew I was going to be trading in the UK because I had connections to major retailers there. So I went ahead and protected myself eventually by changing the brand into my own name. And so I protected myself in the US, in UK, in the EU, essentially at that time, and in Japan. I wasn't considering doing business in China because I didn't have any links there. I didn't have links in Korea. So other countries in Asia weren't really a consideration, but Japan definitely was. And so I kind of put the limited resources that I had into protecting myself in those regions. And I think that's, you know, it's a good question to ask yourself is where really is the business, and focus on that. And also, you know, protecting yourself in different categories as well, because you may be a jewelry designer, so you may not need to protect yourself in the area of apparel or footwear, because you may not ever be considering making those goods. But if you are in fact thinking about making them in the short-term future, you should protect yourself with those classifications too. And don't forget that you have to always renew a trademark. So you have to prove that you're doing business in those classifications. So you can't just arbitrarily register in every classification and sit on it, because if you're not selling product in those classifications, that you won't be able to maintain that trademark. So you have to prove that, you know, on a regular and ongoing basis, which I have been doing since 1995 or 6 or whatever it was.
So Keanan, this is directed at you on that note. How early in your career did you realize it was important to consider how intellectual property played into your creative process as a designer, and what led you to that understanding?
That's a really good question. So for myself, I kind of sussed that out even before college, which was many years ago. In the early 1980s, I started in college. I kind of had this blind ambition that I was going to have my own brand. And so branding was something that and marketing were sort of natural areas that I was really interested in. And so kind of creating a brand and creating a brand identity were things that I knew were really important to me. And I started selling product in college, actually. Within the second year of college, I was making stuff and putting labels in it and selling product, but I wasn't at all protected. I mean, this was an era in London in the 80s where, you know, every other kid was starting a small business or becoming a graphic designer or whatever. But I nevertheless knew that it was important to do that. And so I always thought, well, when I have the resources, you know, I'll kind of get to it. But I had the awareness from the very, very beginning of the importance of, like, every second that your brand is in business, it's adding to the value of the brand. Every person that you speak to, every piece of press that you get, every podcast that you do, every time you're in a blog, it adds to the overall value of your brand and your brand identity. And protecting that is really paramount. As I've said, I've learned that to my detriment and the hard way, but not because I didn't know it. It was because I just didn't necessarily have the wherewithal, the resources to protect myself initially. So yeah, and I think it's something that, you know, if you are an entrepreneur, if you have an idea of creating a product of some kind, and a perfect example of this is Apple. You know, Steve Jobs, he was obviously a huge Beatles fan. If you look at the guy, he had the John Lennon glasses and the whole look. He named his company Apple, and the Beatles actually sued him and said, no, you can't be called Apple. We've got a record label called Apple. And he said, okay, well, we'll do a deal. We'll never be in the music business. And of course, iTunes and all the rest of it, Apple Music happened later. But it's a case of somebody starting something, creating their own brand, and maybe thinking that they can circumvent an existing IP, and you can't. If something's out there and you're infringing on it, and as Paul said, if you get any level of visibility, I had this happen to me when we had our deal with Target. I immediately had a big denim manufacturer from LA come to me and say, oh, we created this stitch on a jean. This is our IP. And I had to go back into my archive and get press and line sheets from 10, 12 years before. And with my lawyer, say to them, actually, no, you're the guys that need to cease and desist, because we've kind of been doing this for a long time. We don't own the patent on it. But this is a signature part of our identity as a brand. So I think just to go back to the original question, and it's a good one. The sooner that you get to grips with that, the better. Saves you a lot of headache later.
And Paul, this is probably more directed at you. So for smaller indie brands, what can people do to protect their work and designs? And this is a complicated one, but what is and isn't protected under copyright laws?
Okay, so the advantages of IP protection are available to big brands just as much as little brands. So there's no true distinction there. You're Gucci and you want to copyright something. You as a small individual starting off with your brand, you have the same rights that Gucci would have in getting a copyright registration. So copyright covers original works of authorship fixed in a tangible medium expression. That's the legal definition. So what is that? Could be a photograph. It could be a graphic design, right? It could be any sort of artwork. It could be a sculpture, and I'm going to stay away. I mean, there's audio, there's all sorts of other categories that can be protected by copyright, but generally the ones applicable on footwear and apparel, accessories, and kind of the fashion world are the ones that I mentioned earlier. Those are very easy to get. Applying for a copyright here in the US is very inexpensive. It's a form that you as an individual can fill out and apply with the US Copyright Office for registration. The registration gives you significant advantages. It gives you access to statutory damages if someone infringes your work. It gives you the ability to claim attorney's fees, right? If you have to hire an attorney to enforce your rights. And in fact, you have to have a registration in the current environment if you're going to sue someone for copyright infringement. So the importance of getting a copyright is incredible. If you've got something that satisfies the requirements, right? Original work of authorship, it's yours, right? It has to be different than something you kind of had access to someone else's work and lifted, basically copied what they're doing. There are standards for infringement in the copyright world. Substantial similarity is standard, right? As opposed to a trademark, which is likelihood of confusion. Keanan talked earlier about, hey, look, if you have a trademark and you find someone in the coexistence, the Apple example he gave, you can at times have examples of two people that have the same trademark in different areas. I want to caution you though, the best example is Delta, right? Delta's an airline, it's a faucet, but if you're in the same space, right? If you're doing the same goods or services, and Keanan talked about that earlier, to decide, okay, am I going to do apparel? Am I going to do a bag? Am I going to do jewelry? You have to figure out which category you're going to register your trademark in. But as far as getting that protection, there's not only copyright, trademark, patent, right? There's trade dress protection. What does it look like? Particularly in Europe, there are strong trade dress rights there. So there's a number of ways that you can protect what's your creativity, what's your creative work, other than copyright. Don't just think about copyright as your only remedy.
Okay, so someone in the audience asked on a more specific note, if you could say a few words about the extent of IP protection on eyeglass frames specifically. So it's functional aspects, surface design, trade dress, trademark, logo/name, and then again, the detractions from some rights. And then again, what category or categories of copyright would potentially apply to an eyeglass frame. So I know that's a mouthful. So if you want to take it a little bit at a time, it's also in the chat if you want to look at the different aspects of the question.
No worries. So I'll take a first crack and then I'll let Keanan talk about it too. So let's walk through a pair of glasses. Okay, I'm going to imagine a pair of glasses, and let's take. I'm going to take a pair of Gucci glasses, big black sunglasses with the Gucci logo on the side. Okay, first thing, trademark, right? The Gucci logo on the side, that's the trademark protection. The look of the glasses, the shape, right? If anything, it could be patentable, right? The question there though is it new? Is it non-obvious? You're going to have to be able to prove somehow that that look is something unique in essence, right? It's novel. There could be technology in the lenses that you might have, right? Depending on what your lens is, if it's shading, there could be some technology there. There might be some proprietary process that you use in connection with creating the film that's on the lens, or some piece of the process to move the market, to move the good from production to market. So there's a number of different pieces of intellectual property that could be in the glass. Let's also take, let's say instead of it's black, let's say there's actually a pattern on it, right? So think about the, it's a design, right? You've got some original design there. That design would be copyrightable, right? And you could get a copyright in that look, right? The whatever design would be on the side of the glasses. So hopefully that answers it by saying there's a lot of different pieces of intellectual property that you can have in a piece of eyewear, and it gives you at least some areas to kind of think about when you're looking at creative development there.
I've never made eyewear, so I've sort of never been in the eyewear business, but I would kind of equate this to, let's say, denim jeans, whereby you've got a product that a lot of different brands make, and you've got certain brands that were at the forefront of turning what was a piece of utility clothing into kind of a fashion item in some senses. So if you look at, say, Levi Strauss, so Levi Strauss created a technology which was putting rivets into stress areas on a jean to build more durability into the denim jean. They also have intellectual properties actually on those rivets. They have a branding on the rivets. They also have an intellectual property on the back pocket, which is the sort of V-shaped stitching, which is called the arcuate. So even though, Wrangler, Diesel, Gloria Vanderbilt back in the day, Gucci, everybody makes jeans, and many people make a 5-pocket jean. And again, there's a big argument to whether Levi were the originators of the 5-pocket style. But nobody can make a jean using the exact identity that the arcuate stitching, the same arcuate stitching, for example, that Levi's makes. They can put rivets in a jean, but it can't be rivets that look like Levi's rivets. Otherwise, they're heading into an infringement. And for those of you that know the denim world, you may know a Japanese brand called Evisu, right? So Evisu was created in the 80s, and it was created as a homage tribute to Levi's. If you look at Evisu, it looks a lot like Levi's, and their logo was originally white lettering on a red background. And their painting on their pocket looks a lot like the Levi's arcuate. In fact, they say it's a seagull, and they say they're called Ebisu because they're in the Ebisu neighborhood of Tokyo. But they came very close to it infringing on, and they even bought Levi's looms as well in the 80s too. So they came very close to infringing on Levi's. But they had some of the same technology as many other denim brands do, and they had some of the same kind of look too. So it's with eyewear, I think it's another area which has a technology, and as Paul said quite rightly, it could be technology in the lens, it could be technology in the materials. You know, I see Warby Parker in their advertising talk a lot about the strength and durability and flexibility of their frames. Is that an IP that they own? I don't know. But that could be, in the case of eyewear, a development, a technological material development that you as an eyewear maker own and have created. Recycling bottles from the ocean, for example, that could be your technology that you've created within eyewear. But I think, I mean, Paul would speak to it better than me, but I think these areas, they're somewhat tricky to own unless you actually own the process of making the materials. You know, if you're in fashion and you have a reflective jacket, but you didn't make the reflective fabric, it was bought from a mill in Italy or in China or wherever, then you actually don't own that technology. You may have created a unique design with it, but it's hard to actually say that you own the technology of reflective materials because it's already out there in the world and it's being used by other brands. So I hope that gives you know, some sort of kind of a broader answer.
So on that note, someone was also wondering, how detailed do trademarks filings have to be? So can you trademark a color or a shape? For example, you know, there's Louboutin red and there's Tiffany blue, and can you trademark those things, or how do you protect that?
Yes, you can, and those are the great examples, right? When people think about colors, it's the red bottoms, the Tiffany box, right? Is often the Tiffany blue is another great example. T-Mobile's magenta is an example out there in the non-fashion world. So trademarks have to be, what they involve is a sample, right, of what the good is. And Keanan talked a little bit about this earlier. There was a change in the US law a few years back that allows you to file what's called an intent to use application. Trademarks are based on use, right? The rights you get from a trademark is from the use, right? It's designed to identify the source of the goods or services. And you've got to continually use that mark in commerce in order to keep the rights in the mark. If you don't, you'll get what's called abandonment, basically. You'll lose your rights in the mark. And so you absolutely can trademark a color. What you'll need is a description of the goods or services that you're trademarking and a category, right? And Keanan talked about categories, right? That, hey, what do you want to do with this? Are you going to make jeans with this? Are you going to make eyewear with it, right? Different goods have different categories that you need to include in your trademark application. And what you want to do is figure out a strategy of, okay, am I going to file an intent to use application and basically hold my place in line? Because what an intent to use application does is it puts basically, you know, draws a line in the sand. As of the date of your application, you're able to basically revert back, right, or relate back to that first date, even though you haven't used that mark in commerce on those goods as of that date. And so if you think, okay, I'm going to go into production, but I'm not going to sell goods across in interstate commerce for 2 years, but I want to make sure that no one else takes this name, this trademark, you file an intent to use application. If you're actually using the mark, you can file an actual use application today. Each one though gets you that date where you start using it in commerce, and you can have protection for those things. The trademark applications, I've seen individuals file them. Lawyers can do them. So there's a broad range of ability. And the USPTO, and I don't know Michelson, I'm sure they'll stick it up in the chat. The USPTO has, and so does the US Trademark, or excuse me, the US Copyright Office has a number of circulars on their website that talk about trademarks and copyrights that you can go and are designed for lay individuals to be able to read and understand. It's not detailed like a patent application. If that's the question, I know you asked how detailed it needs to be, but it is very different than a patent application, or it's on the easier end of the spectrum. Hopefully that helped.
Thank you. Next, what are the legal hurdles designers will face when referencing pieces of art, considering both historical and contemporary art that might have existed for hundreds, if not thousands of years?
It's an excellent question. I think you know, the archives of artists, especially I think in the last 20 years, have become the value has become really tangible. Not that it wasn't before, but if you look at the collaboration, let's say between Jeff Koons and Louis Vuitton, where he took classical artists and put them onto accessories, you know, and used those accessories as a canvas. So as I understand it, those artworks would all have to be licensed in order to do that. I'm not sure now that you can take a painting by Giotto or, you know, whoever, and just kind of apply it to something without licensing it in some way. And I think you do have to be incredibly careful. You know, the way that you can infringe, for example, Andy Warhol famously took photographs of famous people and celebrities, made them into silk screen prints and created original works of art. But those photographs were taken by someone else in some cases, in many cases actually. And I saw recently the estate of the Warhol estate is actually being challenged on their usage of some of these images now. And if you think Warhol created those images in the 1960s, a lot of time's gone by without him being challenged or without the estate being challenged. So I think it's become much more of a complicated area, particularly within, you know, the last 20 years. And I think also, I mean, you know, I was jokingly talking about Disney earlier. I infringed on their copyright because in 2005, my company was doing a lot of recycling and repurposing of products. We were taking products that you could recognize easily in terms of fit and function and repurposing them. So it might be a Levi 501 jean. We would take it and totally customize it, or a tuxedo jacket, or a tuxedo shirt, for example. In the case of Disney, we bought a whole load of vintage Disney t-shirts and sweatshirts, and we repurposed them. Now, the issue wasn't in the repurposing of them, but it was actually what I did in the repurposing, which was to change the Disney logo into destroy and to put a hand grenade in Mickey's hand. So Disney actually came to me because they said, it's not that you're, you know, we recognize that you're repurposing the product, but you're actually, it's a defamation of our brand image. And so they came to me with a cease and desist, and they asked me to supply them with a record of all the products that have been sold and then pay them a royalty on it. And increasingly that is happening with classical arts that is now proprietary, always has been proprietary in some aspect, but is being really policed more stringently now. So, you know, and again, Paul will speak much better to the legalities of it, I'm sure. But the things that you could do in terms of an artistic expression have actually, the licensing industry has curtailed that to a greater degree. So even repurposing and recycling rock t-shirts, for example, you know, again, actually, we did a t-shirt for Target that was the Motorhead logo, but it said Metalhead. And we had Bravado, who are one of the biggest licensing organizations in you know, the rock arena, come to us and say that's an infringement because you know, basically the umlauts over the O's gave it away. It was too close to the Motorhead logo. Didn't say Motorhead, but it was too close. So, you know, I think this is really being policed now more than ever because of the sort of financial aspect of it, and particularly when it gets into a sort of broader spectrum with a large-scale retailer or with a global brand partner. So I think you know, it does, if you're, I think if you're a small business in a, you know, a local business, and maybe you're taking Leonardo da Vinci piece of artwork and putting it onto a handbag and selling it in your store, it may not be an issue for you. You may not ever hear from the Leonardo da Vinci Foundation, but you might. One day they may come to you and say, well, you've been doing this for 10 years. We want an accounting of all the handbags you've sold. Otherwise, you know, we're going to take legal action. So, you know, I think it's, for me, there's still a little bit of a gray area depending on the scale of your business. I'm not saying gray area for whether it's right or wrong. It's clearly, I think it's clearly an infringement. But you get into the whole area of then what Banksy does, is that an infringement? You know, it's sort of, there's a debate that comes with it.
So does that mean repurposing products is protected under copyright and fair use?
I actually can't answer that from a legal perspective. You know, I mean, we did a whole range of shirts which were athletic apparel. So Adidas, Puma, Nike. We went out and found all the vintage shirts. We left, they were, you know, left the labels in there, stitched our labels in there, and customized screen printed them all. These are for stores that were very high visibility, like Bergdorf Goodman and Fred Siegel and Harvey Nichols and so on. The only time we ever had an issue with a big brand, but this is going back 16 years. The only time we had an issue with a big brand was with Disney, but they are famous for really protecting their brand as much as, say, someone like Chanel, you know, who really police their brand. And so I'm not advocating for it. I'm just giving this as an example of what we did within our business, and you know, trying to use that as a perspective more than anything else.
Sure. So couple things there. I think you would have more difficulty today with that, and in particular, it's not necessarily you know, trademark or copyright law. It's a kind of piece of copyright law, the Lanham Act, right, where you have an implied endorsement or you have some affiliation between one brand or another. So if you're repurposing another brand's product, you may draw the ire of that brand for saying you somehow are affiliating, or you're in essence, you're riding on our coattails, you're riding our brand equity to be able to sell your products and make commercial gain, right? So you probably, in my view, today, my guess is Adidas or Nike or someone would take a little different view. Yeah. Going back just a bit though, so on the artistic piece, right, there are things in the public domain, and even I think it's the Matter Museum of Modern Art. They actually have a listing of, here are the things that are in our collection that are in the public domain. Because remember, copyright law, as far as copyright goes, and I'll kind of footnote that, only lasts for a fixed period of time. So currently, if you get a copyright registration, it's the life of the author plus 70 years. In some cases, it can go up to 95, in other cases up to 120. But that's generally as a general rule, okay? But there are other claims that people have. People have publicity rights. So you're featuring me, my individual likeness, or my name, or the false association, right? And the problem Keanan ran into is kind of the brand tarnishment issue, right? That's what Disney was upset about. They said basically, hey, look, sure, it's not a direct one-to-one copy or infringement, but you're tarnishing our brand. It's damaging us in that way. So there are a number of ways that brands can protect themselves other than purely having direct registrations on particular items, right? There's other laws out there that provide remedies and provide their ability to chase you, and unfortunately to stop you from starting your business.
Got it. So I just want to say thank you to everyone submitting questions. I don't think we're going to be able to get to all of them today, but I'm so glad everyone's so interested. One question that I've gotten a few times towards Paul is, it sounds like people want to hear about, given all your background, what has been one of the most interesting cases that you've been involved in related to fashion IP, or more than one.
You know, I am primarily on the transaction side, so I have little bits and pieces of the litigation side, but what you see, at least as cases that I've touched that I think are interesting, are the knockoff cases, right? To me, the biggest danger to any fashion brand, whether you're Gucci or you're Keanan's brand or you're smaller, is counterfeiters, right? And you've got people that are straight out counterfeiters that will copy directly. You've got other companies that are more creative and will kind of alter things. So if you think about the industry that I'm in, patents, right? Design patents and utility patents, those are used primarily to keep competitors from copying the products directly, right? Because oftentimes what will happen is, you know, the litigation, there's some historic litigation between Adidas and Skechers. Skechers didn't take the Adidas marks and put them on the Skechers products, right? You had the Skecher logo, but it was a shoe that was in essence the Stan Smith, right? Which is an iconic Adidas silhouette that everyone knows what it looks like. The great thing that came out of that court case is the Skechers lawyer at one point went over, grabbed one of the shoes and said, see this Skechers shoe? And it's like, nope, that's the Adidas shoe. You picked up the Adidas shoe and said it looks just like the Skechers shoe. Case over. And sure enough, it was a big win for Adidas. So, you know, that to me is the danger, whether it's counterfeit. It's someone on Canal Street, right? There was a raid a few years on Canal Street. I think the seizure was $400,000, but the actual value if those goods had been authentic was around $7 million, right? To me, that's the biggest danger and kind of you know, one of the most fun things to be involved with.
Awesome, thank you. And Keanan, now directed at you, is there something you can tell us about maybe the most rewarding patent that you ever had to file or, you know, fight that you had to have that you either won or lost?
Well, I think that, you know, the trademarking my name obviously was a sensible step towards protecting my growth as a brand. I went into a partnership in the mid-2000s with another entity. And as part of that, the name went into that partnership. That party then defaulted on the agreement that we had. We were able to extract ourselves from that agreement with the name intact, which was a very fortunate position to be in, because many designers don't have that option or opportunity. In fact, they have kind of sold their name lock, stock and barrel and they don't get it back. And, you know, anybody who's watched the Halston documentary, drama series on Netflix or the documentary on Netflix would see that, you know, Halston, what he really cared about as a designer was his name, actually. And at the end of the day, he sold his name and never got it back. And, you know, you see that with Helmut Lang, for example, who sold his name to Prada. You see it with many designers who are no longer, the name is the face of their brand, but they're no longer part of that because they actually sold their interest in that. And so I think, you know, the one thing that I'm very happy about is being able to control and maintain control over my own name, because, you know, you're given that name, it's the name you're given. The last thing you want to do is to be on planet Earth with somebody, you know, doing something creative, but maybe not your creative expression, and certainly not financially rewarding you with the use of your name.
Okay, so since we only have a few minutes left, the last question I'm going to ask would be just for all the aspiring designers here or people who want to get into this industry, what would be some last pieces of advice that you would want to give them? Or maybe Keanan, for you, like, what do you wish you knew when you were starting out?
There are so many things that I wish I'd known at the beginning of my entrepreneurial life. You can't possibly know them all. You are going to learn from the School of Hard Knocks. There's no way around it. But you know, the sensible thing to do, and you know, Paul spoke very well about this earlier, is to sort of do that legwork and protect yourself by using all of the the facets that are available to you without spending too much money in the beginning. But I think it's really important to have very good legal representation. You know, it's worth every cent. It really is. You know, people kind of look at the idea of getting a lawyer as, oh, it's going to be expensive, it's going to be this, it's going to be that. But actually, you know, legal representation protects you in the best possible way. You can do a lot of the initial research yourself, but you know, as soon as you can get great legal representation, it's going to far outweigh. If you think you've got the billion-dollar idea, you know, or if you've got the idea that's actually going to enable you to have a creative expression that can support you with livelihood for the rest of your life. It doesn't necessarily need to be the billion-dollar idea, but protect yourself and make sure that that actually can happen.
And Paul, what about you?
No, well, by the way, I think that's great advice. I mean, it's a little self-serving since I'm a lawyer, but there are a number of groups out there that work with developing artists and designers. Volunteer Lawyers for the Arts is one example that provides pro bono work. You know, Michelson, I know they have all the trainings and the materials out there. It's tough though, right? I think when you're starting out, you think, I have X amount of dollars, right? And so do I do a trademark search and find out if I can keep my name, or do I pay to take this ticket so I can go see the factory, right, where I'm going to have my goods produced? Or, you know, do I hire this graphic designer that I need to actually create the products and to help me to do this? So I recognize it is difficult, and it's a you know, it's almost a Hobson's choice at times to think about that process. But you know, Keanan's example of what can happen when you get so far down the line and you actually hit that level of success, and you haven't done that work in the beginning, I think is really good advice and a good example. I know when I started off practicing, one of the senior lawyers came to me and said, "This is how much you know. This is how much you know you don't know." And then he stuck his arms out and he's like, "But this is what you don't know you don't know." And I think it's the same in any industry, that you go through and you've got a small bucket of knowledge, but there's a lot of things out there that can I was going to swear, I'll just say bite you. I think it's helpful to get good advice up front. So I second that and echo that concern.
Thank you both.
I just also love to say that a name only has value if you're doing something with it, right? So, you know, don't spend months, weeks, months, years deliberating over a name. You know, you kind of have to jump in. The process of getting a trademark, of protecting yourself, protecting your IP, and so on and so forth, should be part of the whole process of getting your entrepreneurial idea up and running. You know, don't sort of wait. I mean, I didn't wait at all. I was, you know, like the bull in the china shop, typically. But you know, you could have this great idea for a name, but then you could find that someone else actually is trading with that name, and then what does that destroy your whole entrepreneurial energy? It shouldn't, because you should just pick another name and kind of get on with it. You know, I mean, is Gucci a great name for a brand? It's a person's name. It means something because the Gucci brand is what it is and has the heritage that it has. But if you take that away, it's just somebody's name. It's the same with Apple. It's the same with most brands. You know, brands that have a really demonstrative name, like Nike, for example, is a great name because, you know, the Greek god of speed or whatever that name represents. It means something. It tells you what the product does. Levi's, it was, you know, Levi Strauss, it was the name of the founders, you know, or the name of the founder. So don't let it hold you back. Kind of, you know, jump in and get on with what you're going to do. And don't maybe be so precious about the name initially if you find that somebody else already has something that they may be using that you may be perceived as infringing on. In that case, just think of another name.
Okay. You guys both for all your wisdom. That closes out our session for tonight. And thank you to everyone here for your participation and your questions. I'm so sorry that we weren't able to get to everything, but hopefully the links that were sent in the chat can be good resources for everyone. And our winner of the $25 Visa gift card is Lauren Palmatier. So if you want to put your email address in the chat box or send it to me, we can send that over. So thank you everyone and have a great night. And I hope everyone learned a lot. And thank you again to our speakers.
Thanks, Dee. Thanks, Keanan.
Thank you all.
Josh, take care. Thanks, everyone.
Bye-bye.